Okay, we have our final presenter of the day. He is attorney Eric Johnson, and he's talking about, legally speaking, what do property owners need to know about all this? Eric attended The Ohio State University. He's earned a degree in economics and then graduated from the University of Cincinnati Law School in 1983. He is a partner in the Canfield, Ohio law firm of Johnson & Johnson with his brother Niles Johnson Jr. Eric is also a member of the Ohio Academy of Trial Lawyers and the Mahoning County Bar Association, having chaired and served on numerous committees over the years. He has also served as a president of the Mahoning County Bar Foundation.
By the fall of 2010, prices had really started to ratchet up, and they were kind of had leveled off, and lo and behold, a competitor arrived on the scene. And the timing was nice because at that point I was representing a group of about 50 or 60 landowners who had property down in Columbiana County. And because of that new competitor entering the scene and offering additional funds, we were able to capture at that time what was the largest per acre price in the state, $2,000 an acre. So what's the current pricing? What's the hot areas? What's going on presently in this play? The core areas in Ohio are Mahoning, Columbiana, Jefferson, Belmont, Monroe, Noble, Guernsey, Tuscarawas, Stark, Harrison, Summit, Portage, and Carroll County, with Carroll being kind of the epicenter of all of this. If you know, that's kind of the heart of the play, and then it extends north and south and a little bit east and west. What are the prices that are being paid to landowners for new leases? The prices are ranging in that core area between $3,000 and up to almost $6,000 right now. The other kind of big component when you're talking about pricing and economics for a landowner is what is the landowner royalty being paid? Because that per acre price is just, that's kind of the icing on the cake. Some people have described it as the first kiss in the relationship. The bigger money will come later once a well is drilled, and so the percentages that we're seeing being paid to landowners are in the 15 to 20% range. Who's taking these leases? I've found over time that there's basically four kind of types of entities that are out there approaching landowners trying to do deals with them. The first type are what I call producers. I mean, these are large companies. They're in the business of drilling and producing wells, and you've probably heard their names before. The second type are what I refer to as brokers. These are people who aren't in the business of producing gas and oil. They really aren't that well funded. They don't have the ability to directly pay a landowner who signs up with them. What their role is, you can almost think of them as a realtor. You're signing an agreement with them, you're listing your property with them, they are going to go try to find a buyer for you, and you will pay them a commission to do that. They typically will aggregate a number of clients together in the hopes that that large package is more attractive to a buyer than a one-off kind of a deal. So you got producers, you got brokers, then you've got a third type that I kind of refer to as a grassroots group. These are interesting. These are groups that are formed typically by the landowners themselves. There may be 2 or 3 or several landowners who begin to talk to their neighbors and begin to have meetings and educate themselves and try to learn as much as they can. They will sometimes use an attorney to advise them. And it's a nonprofit arrangement where they just kind of group up, and then once they kind of have a consensus of the group, they plunge ahead and go forward and do a group transaction with a particular company. The last type of entity out there that we see are what I would refer to as a flipper. This is a company who really isn't in the business of drilling, but they do have money, they are well funded, and they're attempting to see if they can buy a package of leases, aggregate a package of leases, and then having paid for those, take them to a larger producer and sell that package. So those are the 4 types of groups. Of the producers in Ohio, here's who's currently working the state. Obviously, we have Chesapeake Energy. They are the 900-pound gorilla. They are active in all the core counties and then some. They have acquired 1.5 million acres of leases in Ohio to date, and they're still leasing. Another company is Consol, working with Hess. They are in the southern counties, down south of us, 2 or 3 counties. Another large company is Enervest. They're pretty much active throughout the core areas and pretty much all of eastern Ohio. Exxon, through its subsidiary XTO, is active in the southern counties again. Gulfport is another little smaller company working in the southern counties. Devon Energy, very large company, as big or bigger than Chesapeake, has recently taken a position in Ohio, but it's more out in the western part of the state, in the Ashland, Medina County area. Here in Mahoning County, Chesapeake has been very active. They got in here early. They established a very heavy position. There has been a recent entrant to Mahoning County, a smaller company by the name of Hillcorp, who is actively leasing in Mahoning County. In Trumbull County, does not appear to be a core area county. The southern part of the state has had some activity. Chesapeake was pretty active up there. There was a recent acquisition in Trumbull County, a fairly large package company by the name of Carrizo, who was working up there. So that's kind of the larger players and where they're operating. The brokers who are doing they're kind of all over the place. They're typically charging somewhere between a 5 and an 8% commission. The grassroots groups, one of the ones I've kind of followed, who I frankly thought did a great job for their members, was the ALOV group. I think it's the Associated Landowners of the Ohio Valley. They did some nice things and got some good results for their clients, or for their members. And the flippers, again, if you have a very small parcel, or if you're not really in the core area, a flipper may be your only option. So there's, the bottom line here is in my mind, it doesn't really matter who you deal with, whether it's a real company, whether it's a flipper, whether it's a broker, whether it's a grassroots group that you join. The important thing is that you need to have a good lease and you need to receive good terms. So however you get there, that's what you're after. So, we talk a lot about price and we talk a lot about what landowner royalty am I going to get, but there's other stuff in that lease, believe me, that's very important. And a lot of times folks don't think about that. These leases that I'm seeing being offered are about as bad and about as highly slanted in favor of the oil company as they can possibly be. I mean, I've read in my career thousands of oil and gas leases. I've done 2 class action suits in my career that involved suing oil and gas companies because they were shortchanging their landowners. And so in both of one case, I think I represented 2,500 landowners, and the other one almost 1,000. And in both of those cases, I had to read every lease that every landowner had signed. So I've read a lot of leases in my career, and these are about as bad as they get. Now, having said that, if you know what to ask for, they will amend the leases. But like any business, they're not going to give away anything that they don't feel that they have to. So be aware that if you're just going to sign that, that standard lease that's brought to you by the lease agent with no changes and no addendum to it, it's generally pretty awful. And what's really scary is that an oil and gas lease uses language that's very specific to the industry. And there's certain words and phrases in there that the average landowner, the average lawyer, doesn't know unless they're in that business. And so you really have to, you need help is the bottom line. Let me give you an example. This is one of the things that kind of bugs me. And I don't have time, you know, in this short period to go through, put a lease up and go through every clause. I've done those sorts of seminars for lawyers and that sort of thing. But let me just give you one example. And that concerns a unitization clause in a lease. Now that's a pretty complicated term. Unitization, sometimes they call it pooling. Okay, but the concept here is this. If you have a you know, several thousand acre farm out in Texas, they can drill all the wells they want on that ranch. Okay, and they don't need to involve your neighbors. Okay, they got plenty of room to put their wells in. Here in Ohio, you know, our plots, you know, a big plot of land may be 100, 200 acres. Now, with these old Clinton wells that we drilled, okay, that was plenty of ground to put one of those in. But with these Utica wells, that's just, it doesn't work that way. It's not economic. They're going to want to drill 6, 8 wells to drain, you know, 4 to 8 wells to drain a tracts of land that combined amount to maybe 500 to 1,500 acres. Okay? So unless you have a tract that big, you're going to have your land tacked on to your neighbor's land, who also signed leases, and so that they can form this big unit and then get the wells drilled. So there's a real reason for unitization. I get why the companies want it, and it makes complete sense. Okay? But often when a client brings a lease in the door and I'm looking at that unitization clause, I'm seeing in there that there's no maximum size to how big that unit can be. So if everybody signs that kind of lease, and the unitization also says that the lands don't even need to be touching each other. So theoretically, if everybody signs a lease like that, you could put together a 10,000 acre unit with land in Mahoning County, Columbiana County, drill one well on it, okay, and then that triggers what we call HBP, held by production. Okay, that one well being drilled on a 10,000 acre unit is shared by every landowner in that 10,000 acres. And you can see how that will water down your monthly royalty check. So you need to be very careful about how that unitization clause is drafted. It's too early for me to see how they're forming these units. I'm not saying that that's gonna happen, but it could happen. And there's a reason for it to happen, and that reason is time. Right now, the biggest player in the state, Chesapeake, has, I think, about 5 rigs running in the entire state. 5 drilling rigs. Takes about a month, maybe a little less, to drill one of these Utica wells. 5 rigs, takes a month. Okay, they have 1.5 million acres of leased land. You start doing the math, even if those rigs are increased to 15 or 20, or they're saying maybe 40 a few years from now, okay, when you do the math, with that amount of rigs and that amount of acreage, you simply can't drill fast enough to get all the acreage properly produced and drained. So what you're gonna have to do is put 1 well or maybe 2 wells on that big production unit that you formed that may be 1,000 or 1,500 acres, and send the rig up the road. Go drill the next 1,500 acre tract, okay? And then once you've made a lap around eastern Ohio, then you can get around to doing the infill wells. So this is a really important concept that the average landowner is not going to have any idea when he's reading that complicated language in his lease, and it really is something that needs to be thought out and carefully looked at. The other thing that I'm doing a lot of for clients is I can't tell you how many calls I get. How do I get out of this old lease? Okay, I'd love to sign one of these new leases and pocket $4,000 or $5,000 an acre. How do I get out of this old lease? Okay, and the bad news is it's not very easy to do it. Okay, if you're receiving a royalty from an existing well that's either on or near your property, chances are awful slim that you're going to be able to get out of that old lease. Okay. There are some exceptions. I mean, there may be, every once in a while I'll see some special language in a lease that might give you an angle, but it's It's not easy to do. If you're receiving a delay rental, if no well's been drilled yet, okay. Now with these new leases we're seeing, these are what they call paid up leases. So they're paying you 5 years in advance. But the older leases, the Ohio company leases, where we'll pay you every year if we decide we want to. Okay, so 5-year lease, we pay you year 1. And then if they want to go another year, they'll pay you year 2. And if they want to take it another, they could go as many as 5 years. If those payments aren't made timely, if they're late a day, that may give you an option to get out of that old lease. Okay? About 3 years ago, maybe a little longer, I was getting calls from people in counties that were in areas where I thought, you know, why are people after why are they leasing in that county? So I was getting a lot of calls, and clients were coming in, and there was this new company that had showed up from outside of Ohio. It was a big company. I did some research on them, and they were about the only game in town, and they were in areas where there had been little or no oil and gas activity for years, and they were offering pretty good terms. I mean, they were offering $20 an acre per year. And so the clients are coming in to see me, and they're saying, what do you think of this lease? I said, well, we'll go through all the fine print, we'll change, we'll tweak it. Well, what do you think about the price? I said, price looks great. I mean, this is good stuff. $10, $20 an acre per year, 3 years ago. Now, I kind of feel like an idiot, sort of, but was I? I mean, at that point in time, that's what the market was. And it can change that fast. And it turned out that company didn't have some foresight that they knew the Utica was coming. They had no intention or any plan on doing anything with the Utica. They were actually looking at going deeper than the Utica down to deeper formations below it. Now, they ended up flipping their leases to Chesapeake and made an enormous profit in the process. But, you know, were my clients bamboozled or hoodwinked or flim-flammed because of that transaction? You make that call, but I don't feel that bad. I feel I gave my clients good advice at that point in time. So I have heard recently there's some lawyers or law firms out there that are talking about ganging up a bunch of people, and we're gonna go bust these old leases. Be careful. I mean, don't cut your nose off to spite your face. The fact that you have an old lease, okay, all is not lost. I mean, if a well is drilled, you're going to get a lot of money. If you're tied up in litigation for years and years, I don't think your well's going to get drilled. So, some of the fees, the contingencies that I'm hearing that are going to be charged to do that sort of work, it almost seems like the client is better to just, sit tight and hope for the best. The other transactions that are going on, you probably are aware of this, but Ohio producers got a letter early on in this play from Chesapeake saying, hey, we'd like to buy your deep rights. Now, what's that mean? Well, if you're a producer and you've got 100 wells and they're, in a certain township, you hold those leases, and you drilled Clinton wells, and you own that stuff, and Chesapeake wants the deep rights. In other words, you keep, Mr. Ohio producer, you keep your wells, you keep doing what you're doing in the Clinton sandstone. We're not interested in that, but give us the right to drill amongst those wells down into the Utica. Those deals are being cut left and right, okay? So the landowners don't get any of that money, which is kind of aggravating, but that's what's happening. So what I do see sometimes is in those transactions, a landowner will get approached, and they'll come and see me, and they'll say, hey, this company that I've had a well with for 20 years is asking me to sign an addendum to my old lease. What's this all about? Well, what it's all about is that company is trying to sell a lease to one of the big guys. They're trying to sell deep rights to one of the big guys. And there's certain things in that old lease that are problematic as far as drilling these new Utica wells, okay? So if you are approached about an addendum, you know, I want to tweak your old lease, it's an opportunity for you to have a good discussion with the present lessee, you know, what's in it for me? The other thing that we're seeing pretty frequently, this is one of the newest trends, is there are companies out there soliciting landowners to buy their mineral rights. Okay, buying mineral rights. That's not a lease. Now, what's going on is that if you have an old lease, you can't sign a new lease. You can't get the $4,000 or $5,000 an acre. You're stuck with that old lease. So here comes a new company, solicits you with a letter. We want to buy your mineral rights. What does that mean? They're wanting to take. They're taking a bet that someday, either on or near your property, a Utica well will get drilled. Could be a year from now, could be 15 years from now. So they're taking a bet that that may happen. And if that happens, the royalties that would go to the landowner, instead of going to you as a landowner, are going to go to this company that bought your minerals. Okay, it's a one-time payment. It's paid up front. You put the money in your pocket and you forget about it. If a well gets drilled someday, you may kick yourself a little bit. Why did I sell my minerals? If a well never gets drilled, you'll be patting yourself on the back. What a smart guy you were. Because they're making a bet on a future contingency. They're betting that someday a well will get drilled. The money that they're offering you is not the equivalent of you know, what they would get if a well was drilled. They're going to discount that number. So if you are a person who is in need of current money, if you're somebody who doesn't want to gamble, selling mineral rights is certainly an option. I mean, I doubt too many of you in the audience have ever heard of the Collingwood Shale in Michigan. Anybody heard of the Collingwood Shale? Anybody? In the whole lot? I don't see one hand. Okay. From a geologist back here. The Collingwood Shale was a shale play in Michigan that started about 2-3 years ago. They went racing into Michigan, two big companies, Chesapeake and Encana. This is going to be the greatest thing ever. Leased up several 100,000 acres, drilled the first well. First well looked great. Continued to lease. Guess what? That first well just, you know, it went crapola. And the additional wells that were drilled were not particularly, they weren't economic. So what happened? Well, the lease prices that were up here, you know, we had a lot of landowners who were holding out for that higher price. And all the lease agents just left the state, and the landowners were, wait a minute, you know, where are you going? Come back, I'll sign now. That kind of stuff can happen. This is not a done deal yet, this Utica shale play. The Marcellus is a done deal. They've drilled, you know, thousands of wells in Pennsylvania. We know pretty well what they'll do. We've drilled a dozen Utica wells in Ohio. I think only about half of those have been fracked, and the ones that have been fracked have only been produced for a matter of months. So this is not a done deal yet. There's still a lot of stuff that can happen. Jeff Dick did a great job talking about fracturing. I'm going to leave that sort of to the experts, but I find it interesting that I talk to a lot of landowners, and most of the clients that come in to see me here are really well informed. I mean, they know lease prices sometimes better than I do. They talk to their neighbor. Well, my neighbor just got, oh, really? Oh, you know, I write that down. I want to stay on top of the numbers. But they know about that. They know how big these drilling pads are going to be. They know about you know, frac ponds, and remarkably, a small percentage of the clients that come to talk to me want to talk about fracking. And I'm wondering, why is that? And I'm thinking, well, they're probably reading the same stuff I am. And you know, I was looking at a study that recently came out and looked at 16,000 wells that were drilled in the state of Texas, horizontal wells in the state of Texas between 1993 and 2008. You know how many of those wells were found to contaminate groundwater due to the drilling or fracturing process? None. Wasn't a single well. Now, was there groundwater contaminated in Texas because of the drilling of wells? Yes, but it wasn't from fracking. It was, you know, a tank leaked on the surface, or a truck rolled in the ditch with oil, or a pipe burst when they were flowing back a well. I mean, accidents can and will happen in this play. But my clients don't seem to have much concern about fracking contaminating their water wells. We need to be diligent. We need to have the folks at the ODNR keep an eye on these folks, and we need to have proper regulation. But I think that there's we have a long history in the state of Texas that we can look at to say, you know, not seeing anything there yet. In conclusion, it's a very exciting time for the Valley and Eastern Ohio. There's going to be a lot of money and jobs rolling into this area if this play works. We need to have our schools, our trade schools, our vocational schools, our community colleges, our universities hooking up with business and getting our young folks trained so that they can work in this field. That we don't have to have all the folks coming from Oklahoma and Texas to do this work. We need to plan now and plow some of this money as it comes in back to our infrastructure, because this play is not going to last forever. And we need to have other industries developing along the way, so that when the Utica is played out, we still have a strong and vibrant economy locally. Landowners, you need to be careful about what you sign, whether it's a lease or a right-of-way or selling your minerals. Pay attention, be careful, get help. Prices for leases have risen very rapidly. They could keep going higher. It's going to depend much on the success from the wells that we drill. And I don't know if I have any time to take questions, but we do have some microphones they can run around, and if anybody has any questions, I'd be happy to try to answer them. Let them, I'll get you in a second.
No? Nothing?
Test 1, 2.
There we go. Hi, thank you. What kind of infrastructure development are you seeing that's necessary to put all the wells in place or service the wells? What type of infrastructure is lacking, and what type of infrastructure is being developed to suit the needs of the industry here?
The big ones, and we're still very early in the play, but the big ones are going to be these plants that are necessary to strip out the liquids from the gas so that the gas is then dry, clean, has sufficient BTUs so that it can flow into the utilities, interstate lines, and be distributed around the country. So you're going to need these plants, and they're going to be, you know, kind of a regional thing, and the pipelines are going to be huge. We had we talked to a lot of people and different aspects, but a fellow was in, I don't know, a month or so ago, and he said, you know, your infrastructure here in Ohio, compared to, you know, what we're used to out in Texas and Oklahoma. He said it's sort of like trying to put out a fire at the World Trade Center with a garden hose. I mean, that was his description of, you know, of what we need infrastructure-wise to deal with this amount of gas, oil, and condensate that's going to be produced. Anybody else? Fellow back here.
If you have property and you have not signed a lease, and your neighbors have all signed leases, and they end up tapping into your grid or your area, what becomes of that?
Okay, that's a good question, and that's a very common question that I get from clients. In Ohio, years ago, in the 50s, Ohio operated under the doctrine of the rule of capture. And what that rule meant is that if I drill a well in my backyard, right up against my neighbor's property line, we all know and understand that I'm going to be draining my neighbor's gas and oil underneath his property. It's right on the property line, okay? But we operated then under the rule of capture. Whoever captures the oil or gas at the surface of the ground was deemed to be the rightful owner of it. So what you would have were weird things where, you'd have wells drilled, well, you're going to put on my property line, I'm going to put one right on yours. And so it led to a very inefficient way of producing oil and gas. So Ohio has implemented what are called spacing requirements. And so you're not allowed to do that anymore. And so if you're not leased, an oil or gas company is not allowed to drill on, certainly, or even under your property without a lease. And when it's getting ready to drill a well, it has to submit a map to the Ohio Department of Natural Resources showing here's the surface location of the well, here's where I'm going to make my turn, here's where I'm going to go horizontal, and these are all the property owners that this well is going to go under. And they have to acquire, typically from those property owners, leases to allow them to do that. There's basically a 500-foot rule that any property within 500 foot of that well bore needs to be leased. Now, so it's typically not going to happen if you don't sign a lease. We do have rules that really have not been used much in the past that I think we're going to see more and more that will allow an owner of the lion's share of the leases of a proposed well to drill the well anyway. But the chief of the Ohio Division of Natural Resources has the power to put rules in place on a case-by-case basis so that it's fair to that landowner who didn't sign a lease so that he's able to capture some of the income from that well. Okay, so it's kind of like a variance. But aside from that, if you haven't leased, they can't drill underneath your property. Any other questions? Let me get this fella because he's near the mic there.
Thank you. All right. This is going to happen in our neighborhood. I live up in Ravenna, and Chesapeake's actually coming to my house tomorrow. I'll tell you that up front. But my neighbors have said that we don't own the mineral rights. We've lived in this same house since 1972. So I guess my question is, how do you know if that's accurate or not? Who's supposed to check on that? Us, as a homeowner, them? We get legal advice? How do you know who owns the mineral rights?
That's a great question, and I actually was going to address that, and I had it in my notes, and I skipped over it, so I'm glad you asked it. What you're referring to is sometimes, I'll give you an example. I had a client come in that had signed a lease with a company, got a nice price, and waiting patiently for his check. Typically, these checks are cut 3 to 4 months after you sign the lease. He's waiting patiently for the check. It's a 6-figure check, and instead of getting a check, he gets a visit from the lease agent with an apology that we checked your title, and unfortunately, you don't own your minerals. And so obviously, he was not a happy camper. So he came to see me about that. What can you do for me? Fortunately, in Ohio, unlike a lot of other states, we have a statute called the Dormant Minerals Statute. Let me tell you how that works. Let's say that John Smith, back in the late 1800s, gave a deed to Mr. Brown. And Mr. Smith, in that deed, says, I'm transferring all of my real estate to you, but I'm going to keep the oil and gas rights. Okay, so Mr. Brown gets his deed, and he deeds it to his son, and it works its way down several transactions, and here we are presently. And so before you get paid on these leases, they run the records all the way back into the 1800s. And if they find that sort of a reservation, they're going to tell you about it, and they're not going to pay you. Now, what this dormant mineral statute allows you to do is, if you get that sort of an answer, is that it's kind of a use them or lose them rule, okay? If Mr. Smith is going to reserve those minerals back in the 1800s, he's got to use them or lose them. And it's sort of complicated, but the basic rule is that every 20 years, he or his successors in interest, his children or whoever he sells it to, has to do something with those minerals, transfer them, sign a lease with somebody. It's as simple as there's a claim form you can record down at the recorder's office. It basically just says, hey, I'm out here, I own these minerals, I don't intend to abandon them, okay? So he's got to do one of several things every 20 years. So if you find out that you don't own your minerals, we need to look at that and see if there's a way that we can use that statute to recapture them by the landowner. Any other questions? Oh.
You can. Not yet.
Test 1, 2.
Okay. Chesapeake recently sold 20% of their 1.5 million acres leased in the state of Ohio for $15,000 an acre to a foreign company. Are you familiar with that?
A little bit.
Do you think that $15,000 an acre is going to impact the pricing of the acreage right now?
Well, I can tell you that just in the last 2 to 3 months, prices have raced up. I don't know that it's apples to compare those two sorts of things. I mean, if I'm coming in, here's the tough part, and I'll get a call from somebody calling me from Texas or Houston, Oklahoma City. Hey, we're a company out here. We want to get our foot in the door in the Utica. Is there any way you can have access or bundle up, 3 or 4 or 5,000 acres that we could come in and drill Utica wells on? And what I tell them is, I said, look, you got to understand, Ohio, two things. One, Ohio, our parcels are really small. So that's number one. Number two, most of our parcels are already under old leases. Okay, so you got this big checkerboard of leased, already leased, or it's unleased, but so to try to bundle up and create a 1,000 acres or 5,000 acre block that a company can come in and really do its stuff is very difficult to do. So when Chesapeake is getting that type of dollar per acre, it's got a lot blocked up. And if you're a landowner with 10 acres in Coatesville Township, that property you can't do anything with it unless you get control of everything else around it. So I kind of have this theory that we're going to end up with 7 or 8 big companies that got leases scattered all over the place, here and there, and they're going to get in a room somewhere, okay? And there's going to be a big swap fest where they're trying to, I'll trade you my Babe Ruth for your Yogi Berra, I really see that sort of thing happening someday, because otherwise I don't know how they aggregate the blocks. Because really the efficient way to do this is you need about 500 to 1,500 acres to put 6, 8, or 10 wells on. That's the best and most economic way to do it. Anybody else? What? Okay. This fellow's asking me about injection wells. How do those work? I've done a couple of those representing a landowner. Okay. First of all, when you sign your lease, if you're going to sign a lease with Chesapeake, I shouldn't I shouldn't separate out a particular company because they're all very similar. If you sign a lease with one of these larger companies, you will typically find language in it that gives it the right to use your property for injection purposes. What does that mean? Well, you know, Jeff Dick was up here showing you pictures of, you know, how you're injecting brine and frac fluids back into the earth, okay? They basically build a big swimming pool on your property, put up a guard shack, and have trucks driving through, you know, 12 hours a day, filling up the pool and injecting. Now, what compensation do you get for that? Under the lease, I mean, it's awful. It's $20 an acre a year, or I mean, just it's really, you know, terrible. So scratch that out, okay? They'll let you do that. Take that out of your lease. But I have negotiated a couple where a company came to the landowner right up front, says, look, we want to sign an injection well lease with you. Okay, we're not going to produce this. This is going to be in it. So they were up front about it. So the landowner knew what they were getting themselves into. And you know, the first thing I said to the landowner was, you really ought to go look at one of these things. You really ought to go visit. Have them take you, because they had other wells that they had drilled and were operating. Have them take you to the facility. You need to be able to visualize and know exactly what you're getting yourself into. And frankly, that sort of applies to just a regular old lease. I mean, if you got some time, go visit one of the wells that they're getting ready to drill or have drilled, or at least get on the internet and look at the videos. You know, there's all kind of stuff on the internet. You need to know what you're getting yourself into. But getting back to your question, the transaction that I did, the landowner compensation is going to be based on a percentage of how much money is generated by that well, and they basically charge by the barrel, you know. So if the projection that was given to us was fairly accurate, it was, you know, it was a pretty nice. This was an old industrial land. It wasn't generating any income to the client. It's probably going to be a very good deal for them.
Yes, this is a follow-up question for your last topic. This whole oil and gas play is going to change real estate transactions forever. If you do a normal real estate transaction, you have to do a title search on a piece of property. But that tells you absolutely nothing about oil, gas, OGM, oil, gas, and mineral rights. If you want to buy or sell a piece of property, how do you find out, again, who owns the OGM, if they're available, if they're not available? I understand it's very expensive and it takes a very long amount of time to do that research. Does your office do that kind of research? Do you recommend anyone in the area that does that kind of research? And if I sign an agreement for a piece of property, it may take 3 months, 6 months to find out an answer. I mean, all the oil companies have the courthouses just clogged up with people trying to do this research. If I buy a piece of property, I want to make sure I have the OGM. How is this going to take place? And give me a typical example of a real estate transaction if you've been involved with one, and the times limits that were involved. Thank you.
Yeah, I'll give you. I got a good example. First of all, you know, just kind of my brother and I had lunch yesterday with some folks, local title company, on exactly this issue. That you know, when a lot of these title insurance policies are not, you know, they're not guaranteeing that you've got your mineral rights, and don't want to guarantee it. They've specifically said we're not going to go there, and we were trying to explain maybe you should. Maybe this is a business opportunity for you to come up with a product, an insurance product, and you're going to have to charge appropriately for it. But people want to know. They want to know. Am I getting these minerals? And will you write insurance so that if I don't, you're gonna cover me for that event? So it's a good question. I'll give you an example. I have a fella I know who, there was an auction of real estate here not too long ago. It was a fairly large parcel. It was in a good area, you know, lease price wise. And they were thinking that, well, I'm going to go to that auction and I'm going to buy that property, and nobody's going to factor in, you know, these great oil and gas rights that come with it. And I said, you know, you really ought to have a title run on that before you do that, and get me a copy of what the abstractor comes up with so I can take a quick look at it. And lo and behold, 5 months, you know, prior to this auction going forward, that landowner had already signed an oil and gas lease. So you know, if he had gone into that transaction without that knowledge, he could have gotten burned. And in fact, that property seemed to have sold for a multiple of what it was probably worth. And I'm wondering if some uneducated buyer did exactly what my friend was trying to do and just didn't do his homework.
What kind of company do you contact to check oil and gas mineral rights on a piece of property?
Here's the problem. We have some very good title companies in this area, okay? But what they do, I mean, they're good at going to the courthouse and gathering up all of the documents that affect a particular piece of property. They're very good at that. And when you get a title report on your title insurance policy, they will list on, I think it's Schedule B, here's everything we found at the courthouse that affects that property. What I've seen over my years of practice is most homeowners never look at that before closing. They just, I got title insurance, that's all I need. You know, all the title company is saying is, you know, here's what we found. They don't do an analysis to tell you what impact those things they found of record might have on your property. And I think they're uncomfortable doing that, particularly as it pertains to natural gas. So I think you gotta first get that stuff, and then you gotta bring it to somebody that knows something about oil and gas. Yeah, his question is oil and gas rights are recorded at the courthouse, so you can find them. True, but what if you find a lease that was recorded in 1982 by a prior owner of the property? What do you know about that lease? It was a 5-year term, recorded in 1982. Well, you got a copy. Now I'm looking at a lease, I see that the owner of this property back in 1982 signed an oil and gas lease that had a 5-year term. Is that lease in effect today? Why not? What if a well was drilled? Well, there isn't a clear answer. I mean, you got to do your homework. I mean, I can't tell you how many times I'll ask people, do you have a lease on your property? No. Are you sure? Yeah, I'm sure. I don't get any royalties. How long have you owned the property? About 5 years. Are there any wells close to your borderline? Oh yeah, there's one right on my neighbor's property. It's 10 feet from the borderline. You're not getting a royalty? No. Did you ever call the oil company that owns that well and tell them that you're the new owner of that real estate? No. Was I supposed to do that? Well, how else would they know? And so the oil company has been escrowing or setting aside for the last 5 years those royalties, waiting for somebody to show up and claim them. And they will pay it when the landowner comes and shows. But just because, you know, I look at the record and see a lease, I don't know whether that lease is active, inactive. I mean, there's a lot of homework and investigation that needs to be done to find out, you know, just because it's of record. I mean, it's you know, it's kind of like taking a novel and cutting all the pages up and throwing them in a big stack and saying, well, here's the novel. Well, somebody's got to go through that stack of pages and figure out what the story is.
Two.
Hi. So at the beginning of your speech, you were talking about how all the jobs and economic benefits that are going to come from fracking coming to Ohio, and And you said that it's really needed right now because a lot of corporations have moved business to China and all the transportation and stuff like that. But it seems to me that a lot of the companies that are bringing fracking to Ohio are the same companies that abandoned Ohio and took all the jobs overseas. I mean, Chase Bank has a booth over here, and that we all know that Chase makes their money by ripping people off and peddling political influence. And now you're talking about all these things that individuals need to do in order to protect themselves from being ripped off. I'm wondering what we can do as a collection, as the whole population, what we as a mass can do to protect ourselves from these vampiric corporations that are coming in. Are there any legislators or anybody working on changing the laws that can actually protect all of us instead of each of us having to fight and protect ourselves as individuals?
What kind of protections are you thinking of, more specifically?
I'm asking you what kind of protections that we could get by lobbying our legislators or trying to get
well,
our
look, on the out-of-state companies coming here, this type of drilling we've never done here before. I mean, we don't have rigs in Ohio that are capable of doing the type of drilling that they're doing. We don't have companies, I'm going to throw out a word you probably won't, Halliburton and Neighbors and Schlumberger. I mean, these are large companies with expertise that we simply don't have. Not saying we couldn't get that over time. Not saying that they might not, begin to open offices up here in Ohio. But this is really sophisticated stuff. I mean, we've been drilling through shale. We've been drilling through the Utica shale in Ohio for decades. I mean, drilling right through it onto deeper formations. We've known that there was oil and gas in that shale. We saw it on our way through, but we never knew how to get it out economically. And that technology is only, very recent in the last couple of decades, and it's changing rapidly. So, we need help from the experts, and unfortunately, most of them are, coming from out west. That's just kind of the way that it is. Not to say, we couldn't, get boned up on that stuff, but sure.
In New York State, they've declared a moratorium on fracking until this technology can be tested more and we can verify that these things are safe. Are there any political groups or legislators who are talking about willing to have that kind of thing happen here in Ohio?
I read something in the paper. Senator Hagan has a concern in that regard. I think that for the most part, particularly our legislators here locally, see a huge opportunity here and are not inclined unless they see some evidence. I mean, 16,000 wells drilled in Texas and not one? I mean, how much study do you need to do?
I've heard studies that out of like Penn State that talk about all these things that you're saying that kind of get blown up in the media, but there are other studies about the health effects and the groundwater pollution and people getting sick. I mean, I've seen documentaries of faucets starting on fire, like the water coming out is flammable.
Were you here for Professor Dick's seminar?
No, I got here too late.
Okay, you should have sat in for that.
But I don't trust these studies because I know that the universities that are putting out the positive studies all get their money from the same corporations that want to do this kind of drilling.
I think this is Attorney Eric Johnson. I don't know if he's qualified to talk about the studies themselves. He's here to talk about the law. So if anybody else has a question, we have about 12 minutes before this whole thing is going to wrap up this morning. If you have a question, why don't you come over here and we'll try to have Attorney Johnson answer that for you. Come on over here. Thank you.
On the terms of these leases, they're a 5-year lease. Is there some kind of an open-end thing favoring the oil and gas companies that can force you into signing and make the lease go a longer term?
Yeah, good question. By far, the most common lease form that I'm seeing proposed to clients, I refer to it as a 5 plus 5 lease. And what that means is that and it's a paid up lease. So they're paying you an amount that's buying the first 5 years. And within that time frame, they need to get a well drilled either on or near your property and begin to send you royalty checks, okay? If they can't get that done within the first 5 years, they have an option, it's not a requirement, but an option to make another payment to you at the beginning of the 6th year of the same amount that they made to you for the first 5 years, and that buys them a second 5 years. So in effect, these are really 10-year leases rather than 5. I'm sorry? Then it's over unless, and this is an oil and gas lease has basically what we refer to as a primary term and a secondary term. The primary term is measured in a specific number of years, 5 years or 5 plus 5 years, okay? And then if they get a well drilled within that time frame, then the secondary term of the lease kicks in. And the secondary term, by necessity, is open-ended. We don't know how long a well's going to drill after it, or how long a well is going to last after it's drilled. I mean, we have wells in Ohio that have been operating for 100 years. So the lease language will read 5 years and then have language similar to "and so long thereafter as oil and gas are produced in paying quantities." That's kind of a pretty common phrase, although again, these leases that I'm seeing from the big companies, they've got all kind of wiggle room on that language, and it's not as well defined as I'd like it to be.
I have a question for you. Since technology is moving so fast there, and a lot of us probably signed leases 20 years ago there, and the wording was vague there, how can those leases be considered viable when all of a sudden, 20 years ago they were just drilling shallow wells, and now they're going deeper and deeper and spurring out and fracking them there?
Yeah, that's a common question that I get.
When we signed the lease, they only had one type of drilling.
Nobody anticipated that we'd be here when you signed it 20 years ago.
Right.
A lease is a contract.
Things change, so why should we be held to that contract when they're going to come in and do different things than what we agreed to begin with?
I'm not saying that you could never convince the judge of the track that you're taking, but I can tell you that generally speaking, our courts are bound by legal rules that say unless there's some sort of a fraud going on here or something very unusual, a signed written contract is going to be enforced according to the terms that are set out therein. And that's why it's so important for people to scrutinize those terms. Most leases don't, a lot of people will say, well, maybe this lease only applies to the Clinton sandstone. Could you read it that way? But when you read the lease, it talks about all formations. It's not limited to the Clinton. And so I'm not saying you could never win that argument. I'm just saying you've got an uphill battle with that one.
Also, why aren't the leases taxed like the people that own the upper layer there? I mean, they claim they own what's underneath there, but yet we have to pay taxes for to the township, to the states, and the government there for what we own. Well, then the lease owners should have to pay taxes for what's underneath there.
You're going to see a lot more of our counties taking a close look at assessing values of real estate and factoring in these mineral rights. And what I like to see in leases that I negotiate for my clients is a clause that says if that happens, if we drill a big well here or we drill one on the neighbor and the county comes in and says the land value, considering the mineral rights, has just tripled and your tax bill has just tripled, that the lion's share of that increase in value is paid by the lessee and not by the landowner. No.
Thank you. Hi, thank you for taking my question. I really appreciate it. Ohio has no jobs because large corporations abandoned workers here for China. Now these same corporations are bringing jobs back, but not the jobs we deserve. They want us to absorb their toxic waste, accept their polluted water, steal our land.
This is a legal question and not a political arena. Ma'am, he is an attorney. He has nothing to do with that.
I mean, well, I don't know about corporations, but I mean, we do have a regulatory structure in place through the regulations through the Ohio Department of Natural Resources, which were, I don't know if it, talk to your congressman. I mean, you know, that's.
Congressman, at times, talking to lawmakers doesn't work.
Okay,
If people want to fight for clean water, they need to stand up for themselves and speak out. The people here at this conference make up their studies on the people to do that.
Okay, we're going to wrap it up now. You know, a
On
lot of
that
people
note,
have
thanks
actual
very much.
questions that they need to and not a political thing. So we're going to wrap it up here. We want to thank Attorney Eric Johnson for coming out, answering the questions today. We appreciate him coming out, as well as all of our speakers. And we just have a few minutes before the morning session is going to wrap up here in the arena. So if you want to walk around still and mill around to some of the vendors who are still out here, you can do that. And we appreciate you coming out. We appreciate everybody taking time this morning, this afternoon. Thank you.